The recent decisions out of the Quebec court in the Canadoil Forge Limited case illustrates the critical importance of proper procedure and full disclosure in corporate insolvency proceedings, and especially in that case when the motion was being made on an emergency basis without giving notice to the other side, which is called an ex parte motion. The initial application failed because it was found to be procedurally unfair. There wasn't adequate urgency. They were trying for overreaching relief, and at that point, the business was still viable. The second application, which followed proper due process, was successful. And that's what this week's Brandon's blog is all about. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So shoot us a message, give us a phone call. We would love to speak with you. Ira Smith Trustee and Receiver, Inc. is a true family business. We are not for everyone, but if we accept you as a client, we will treat you with the utmost respect and give you the best possible professional advice and guidance to get you or your company back to leading a stress-free life and your debt under control. I hope you enjoy the rest of the video and you find the information helpful.
Picture this for a second. There's a secret court hearing happening right now. Only one side of the story is being told, and based on that alone, a judge is about to decide the fate of an entire company. We're talking over 100 employees, millions of dollars in revenue, the whole shebang. It sounds like something straight out of a legal thriller, right? Well, it's not. It's exactly what happened in the absolutely fascinating case of Canadoil Forge. So, let's get into it. So that really begs the question, can a company's entire future be decided before it even gets a chance to defend itself? And the answer, believe it or not, is sometimes. Yeah. This brings us to a really powerful, super high-stakes legal tool that's at the very heart of this story, the ex parte motion. So what is that? Well, you can think of it as a kind of legal ambush. You're basically asking a judge to make a huge decision without the other side even knowing you're in court. Now, because it's so one-sided, the bar to get one approved is incredibly high, and it comes with some very, very strict rules. Okay, so let's meet the company at the center of all this. Canadoil Forge Ltd. And look, this wasn't some small fly-by-night startup. This was a really established manufacturing business that had been around for more than 40 years, operating on both sides of the Canada-US border. And this, right here, is the human side of the story. We're not just talking about assets and balance sheets. We're talking about over 100 people who worked at its Quebec facility, whose jobs were literally hanging in the balance while this corporate battle was playing out. On top of that, the company was a pretty big economic engine, bringing in around $30 million in revenue every year. This wasn't a business that was failing either. In fact, there was evidence showing it was actually profitable. So, what on earth went wrong? Well, things just unraveled incredibly fast. It started in June when the Royal Bank of Canada, RBC, started getting worried about some hidden tax debts and, questionable transactions. By July, they weren't just worried anymore. They were demanding full repayment of their $12.5 million loan. And then, by August 19th, they were in court trying to push the company into receivership without even telling them. This first attempt in court was, to put it lightly, a total disaster. It pretty much became a textbook example of how not to do things, especially when you're asking a judge for something so extreme. So why did it fail so spectacularly? Well, for a few big reasons. First, the bank just couldn't prove that things were so urgent that a secret hearing was necessary. Then, they filed their key documents just a few hours beforehand, a huge no-no. They also totally failed in their duty to give the court the full story, and that includes the facts that actually helped the company's case. And on top of all that, they asked for these sweeping powers that went way beyond just protecting the company's assets. And the judge, Justice Morin, well, he was not impressed. This quote from him just says it all. He's basically saying, whoa, hold on. You can't expect me to decide a really complicated case based on a completely one-sided story. And just like that, the motion was dismissed. But wait, the story doesn't end there. Not even close. Just 10 days later, the lenders were back. Same court, same judge. And here's the crazy part. The company's financial situation hadn't really changed at all. But this time, the outcome was completely different. I mean, just look at the difference between the two attempts. It is night and day. The second time around, they gave proper notice. They came in as a united front, with the other major creditor, Fiera, joining them. But the real game changer? By the time of the second hearing, the entire management team at Canadoil had resigned, leaving the company completely adrift. All of a sudden, the situation looked totally different to the judge. Now the company had been notified. The creditors were all on the same page. And, crucially, there was nobody left to steer the ship. The court now had a really compelling reason to step in and appoint a receiver to take over. And this time, the motion was granted. Wow, so what can we all learn from this corporate roller coaster? This case actually has some incredibly valuable lessons, whether you're a business owner, a lender, or you advise people in these situations. It really boils down to 4 key takeaways. First, if you're a company in trouble, you have to be transparent. Hiding problems just makes things worse. Second, for the lenders out there, process matters a lot. Taking shortcuts can sink even a solid case. Third, you have to have a plan and show the court exactly how you're going to preserve the company's value. And finally, you got to remember that courts today expect you to think about everyone involved, from creditors to employees, not just about yourself. So, here it is. This is the crucial point of the whole story. In those 10 days, Canadoil's debt was the same. Its profitability was the same. The basic business issues, all the same. The only thing that truly fundamentally changed was the legal process and the fact that the company's leadership was suddenly gone. How the case was presented made all the difference in the world. Which leaves us with one final thought to chew on. It's so easy to get caught up in whether you're right or wrong in a big dispute. But this case proves that in a crisis, having a strong position just isn't enough. You have to ask yourself, is your process just as strong? Because as Canadoil Forge found out the hard way, sometimes that's the only thing that matters.